Now in a
Welcome back to the Law News Network. We were just seeing testimony from the medical examiner, and what we know is that we did not have live testimony because the actual medical examiner was not available for this retrial. But what we do have is David Pietro on the line with us. David, how are you today?
Good morning. Thanks for having me.
Oh, thanks for joining us today. What we have here is we have a retrial of the penalty phase of a bifurcated trial for John Valerio here. What we know is that the Supreme Court essentially decided that the jury instruction in which the court provided in the first trial, the depravity of the mind was not sufficient or was too vague for the jury members to actually to be able to understand. Do you mind talking to us a little bit about that today? What do you find in regards to jury instructions? How important are they in a trial? Because we see here in this case that the whole penalty phase of this trial was essentially overturned. So how important are jury instructions to a case?
Number one reason why cases get reversed are jury instructions. They're critical. And a lot of times the lawyers are tired, the judge is tired because they're in the middle of a trial, and now they're dealing with jury instructions, and it's the most important part because that's the record or the instructions that the jury is going to consider, and is the rules that they're going to follow. So the depravity of the mind issue is obviously one of the aggravating factors that the jury is to consider for the death penalty portion. So I can understand why that is a vague concept. I think the judge would have to define what depravity of the mind is. It's got to be the malicious nature of the crime or specific things that the jury is to consider, not just depravity of the mind. It's probably not common in our language, not known enough. What exactly does that mean? I think more specifics need to be pointed out.
Exactly. And so we know that that's what the Supreme Court that's exactly essentially what the Supreme Court stated, that we don't know exactly what depravity of the mind is. We know what torture is, but depravity of the mind could be I guess defined in a numerous amount of ways. So the Supreme Court ruled in deciding between the death penalty and life in prison, the jury has to consider mitigating evidence. In mitigating, we have aggravating and we have mitigating factors. Talk to me a little bit about the importance of aggravating and mitigating factors in a first-degree murder trial.
Very, very important. Obviously, death penalty cases are bifurcated, and you generally get two lawyers. You get one to try the guilt or innocence, and then one to advocate on your behalf on the aggravating and mitigating factors before the jury. So these are what the jury is going to consider, whether the aggravating factors outweigh the mitigating factors. And the aggravating factors are generally specifically defined for what the jury is to consider, whereas the mitigating factors usually have a catch-all at the end that says any and all things you may consider as mitigating, which gives the defense wide latitude in presenting mitigating factors. That's probably why in this case, the friend from church that was presented as evidence was allowed in because of that just broad catch-all of allowing any and all mitigating factors to be considered. So this is, this is kind of standard on how death penalty cases are handled. The only difference is happening, what you're seeing nationwide is, like you see in my state, Florida, and the Supreme Court said for federal cases, the jurors had to be unanimous. The states did not have all that. Now, our state Supreme Court has said here in Florida that we're going to follow the federal model, that you need a unanimous decision. I'm not sure that that's the case in Nevada, but it seems that that's where the law is pushing in this nation, back to deferring to the jury, not the judge, because it's gone back and forth over the last couple of decades. And allowing or requiring the jury to be unanimous in its decision.
Right. And so I know that you discussed the individual, I believe the person from church or the religious individual who came in and testified on his behalf. How important are these mitigating factors when we have a defendant here? Because we already know that the jury members found him guilty, but we know, and we also know that Ms. Blackwell sustained approximately 45 stab wounds to her body. So how important is it in weighing the mitigating factors versus the aggravating factors in this phase of the trial?
I think it's very important because I think the jurors want to know, is this just a sick, deprived individual, a Ted Bundy, so to speak,
Hmm.
somebody that is just a killer, and they're going to kill whether they're in prison, they're going to kill whether they're in the streets, or is this somebody who fell off the wagon at some point in life? Did they have mental health problems? Were they abused as a child? Did they have mental deficiencies that, like mental retardation and things like that, that give the jury at least not excusing the crime, but mitigating why this individual may have been in this particular situation. So the 45 stab wound would be an aggravator, but his life prior and what got him to do this level of crime in his background is for the jury to consider whether this is an isolated incident where he should serve life, or is he just a killer that's going to kill human beings no matter what?
Right, and we know from this trial that the juror members actually have to consider life without the possibility of parole, life and the consideration of parole after 20 years, or the death penalty here. Also, another thing that I wanted to talk about that you spoke briefly about is how often this actually occurs, in which jury instructions are not properly given to the juries, which essentially overturns a case. We know in this case, this is the third Nevada death sentence which has been overturned for the same reason. We have 16 out of the 85 condemned inmates on Nevada's death row assert similar claims on appeal. Do you have any examples that you could show us, even from Florida, in which there are similar circumstances?
Yeah, many times, many cases are overturned on jury instructions, but death penalty cases are extremely scrutinized. In Florida, if you are sentenced to life or some other term in prison, you have a right to an appeal at our district level courts. But you do not have if you don't prevail in the district level courts, you don't have an automatic right to an appeal in our Supreme Court. Now, death penalty cases is totally opposite. It goes directly from the trial court, directly to the Supreme Court, and the Supreme Court analyzes every little piece of evidence and jury instructions and all objections, and were the lawyers sufficiently representing the defendant. And I think the belief of that is back in the 70s, 60s, 50s, 60s, 70s, that the death penalty was overutilized and potentially innocent people were sentenced to death. So I think this is why part of the procedure to ensure that if the death penalty is given, that nothing's missed or not overlooked, and everything is sufficiently litigated. And I think we're finding in this country that the death penalty is becoming less and less utilized, and for whatever reason. And there's been studies that say that when crime goes down, which crime is down in our nation over the last 20 years, the support for the death penalty actually goes down. And when crime goes up, the support for the death penalty goes up. So I think as you see prison sentences longer, people staying in prison longer, in most states, you're finding that crime is down, and there's probably a direct correlation to that. And because of that, I believe the support for the death penalty is also going down as well.
Yeah, I think that's a great distinction that you made here, in regards to the crime being down and then requests for the death penalty being falling as well. A lot of the times we see here that, or a lot of the cases that are brought to light or that are high-profile cases regarding convictions that have been overturned are due to, a lot of the times, it's DNA. So it's quite interesting to find that we have jury instructions are the reason why that that the death penalty was overturned, or the penalty phase was overturned, and so we have to relitigate this matter. So one thing that I want to discuss with you is the fact that we are at the point now where we have to retry this matter, or the prosecution and the defense have to retry this matter. So it may not be the same prosecutor, and I'm speaking generally, it may not be the same prosecutor who originally tried the case. As we know, this case was originally tried in 1988 and then was overturned in 2002. So there's been a long period of time in which the case was first litigated, and now we're in 2017. So explain to us how difficult it must be, because we even saw some testimony from the retired detective who initially investigated the case. The defense attorney was cross-examining him, and they went into some banter for a little bit as to the fact that the detective was testifying as to things that he didn't necessarily see or that he didn't have firsthand knowledge of. He was testifying as to facts that he saw in the police report, essentially. So tell me, or explain to us and our viewers, how can the period of time between the first case, which was tried in 1988, to this retrial, how does that affect this case?
So cases for prosecutors don't get better over time. That's not wine gets better over time. Cases doesn't get better over time. Memories fade. This is why the defense loves that cases get older. People die, witnesses die, evidence becomes, or your witnesses get into trouble, and then they have their own problems and their credibility is questioned. So cases like this, and also the jury loses or starts to think that, well, he's already been in, they probably assume he's been in prison this whole time, especially if this is the retrial of the death penalty portion. They start to believe maybe he served a sufficient period of time for the crime, so you get jury nullification potentially. So the cases that get old and have to be retried are very hard, and I think that's why prosecutors, when they seek the death penalty, it shouldn't be overutilized. It should be for the right cases, where it's really the exception to the rule, not the rule, because these issues come up, and I think a lot of times, and there's no proof of this, but I think Supreme Courts around the states, when a death penalty is overutilized, I think they become highly critical of the case and reverse it. We had a case like this in Broward County, where I live in Fort Lauderdale, where it was called the Nickelodeon murders, and you may be covering the retrial again, Pablo Ibar. The Supreme Court reversed this case multiple times. I mean, not once, but I think now we're on our third trial. And it was from the early 1990s. It was a double homicide where one of his co-defendants was actually found not guilty. So, and my belief is the Supreme Court, the makeup of it now, no matter what that case goes up, how it goes up, it's going to be reversed. They just don't like the case. So, really, these cases, when the state or the district attorney or the state attorney's office seeks death, they really got to consider that, is this the right and appropriate case for the longevity of fighting for this death sentence.
Great point. And another great point that you made was the fact that a lot of the times when we have such a long period of time from when a case is first litigated to when it's retried, or simply just retrying a case within a short period of time after the first trial, we have incidences in which witnesses aren't available, and we have the same scenario here in which the medical examiner is not available to testify. And essentially, what's happening is that we are just receiving the testimony from the first trial. There's an individual in court who is reading the testimony of the medical examiner in this case, and so we have essentially. In my opinion, this kind of would affect the case negatively for the prosecution, because of the fact that there's no live testimony. The jury members are just seeing someone reading from a book or reading from the transcript, excuse me, as to what the doctor actually the doctor actually testified to in the first trial. And so this also leads to not being able to question the doctor about maybe other factors that the defense or the prosecution may have seen. So how does that affect the case? Do you think that will essentially affect the outcome of the case at all? The fact that there's no live testimony from the doctor.
Yes, I don't think there's anything more boring in a trial than reading a transcript. I saw a juror one time lift his hands up and go boring under his breath. In the middle of a trial. It is boring. I mean, it's boring for me as a lawyer. It's boring. It's hard. It's like having somebody read a novel out loud or read a play script out loud. it's really a horrible way to put in evidence. But if that's your only evidence, you don't want to get a directed verdict or not make it to the jury. So you got to put the evidence in. And then what the prosecution needs to do is in their closing argument, walk through that testimony piece by piece so the jurors didn't miss anything.
Okay. And so I guess quick question for you. I know that we don't have you for that much longer, but what are you thinking from what we've seen thus far in this trial? Do you think that what do you think the jury's going to come back with?
I don't know if the prosecutors were very enthusiastic about this case.
Right.
I think they put on a very limited amount of witnesses. I think it's going to come back life without parole, and I think that's probably where it's going to stick. If I were to put my chips on the mahogany.
Any particular reason for the life and not death here? Because it was a heinous crime. I mean,
right, and the victim wasn't a mom with 3 children, and I hate to say that, but it's true. That comes into play is who's the victim, the longevity of from the incident to where we stand now, and I think the prevailing belief in this belief, or less of a belief in the death penalty as time goes on, and through this generation, I think is going to play a major factor in not returning a death verdict.
Do you think the fact that, I believe that our generation at this point is a lot more, I would say, liberal than maybe it was in the past. So do you think that the time frame from between 1988 and 2017, do you think that the fact that we have a different group of members, a different group of jury members would have anything or any effect on how they view Lisa Blackwell in this case? The fact that she was a prostitute, the fact that she was not a mother, do you think that that has, that the time lapse has any effect on how they would view her here?
I think so, and every community is different. Broward County is very liberal in its registration, but I call people in Broward County California Democrats. They're liberal people, and they're in socially,
right.
But when it comes to crime, they're not liberal
right.
In that sense. They're very conviction oriented. So that has a big play as the composition of the jury. And as you know, that's the human factor in trials, what makes a trial risky, no matter what, because of the human composition of the jury. So I would agree with you. Yes, I think that's going to play a role. I don't know the community well enough. I mean, it's Vegas, so it's or Nevada, so it's a different kind of state. It's not a southern state or northeastern state or something like that. It's hard for me to determine how they would perceive it or if it's changed, if any, and perception-wise from the 80s to the present.
And we know from last week, I believe it was last Thursday, we had some testimony from an actual, I believe it was a psychologist, who testified to the fact that the defendant had, I guess, issues, being the fact that, he did not have a mother when he was growing up, and testified to a lot of personal issues as to the defendant. Do you think that personalizes him at all for the members of the jury?
Yes, he did commit the crime. We do have to convict him, but he's not like us. He had a much worse lifestyle growing up. He had no mother. He never got an education. He has mental health problems, alcoholism, drugs, etc. And it gives an explanation, not an excuse, but an explanation as to why this happened, and it mitigates the issue of death versus life.
And do you think that the defendant taking the stand for an allocution helps him at all, or do you think that it does not?
Yeah, I don't know. Probably doesn't help him. It'd probably be better to be quiet.
Well, that's the choice that they make, the decision that they made. And hey, we never know in this case. I mean, the jury members may feel bad for him, being the fact that he had, some mommy issues. I don't want to make light of that. But essentially, I just want to thank you again for being with us today. You provided some great insight into this matter, and I know that we'll have you on here again. So thank you so much.
Wonderful. Thanks for having me.